Council of the Town of Fort Myers Beach. It's 10 a.m. and stand for the Pledge of Allegiance, please. Pledge allegiance to the flag of the United States of America, the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay. The first item is the update on the Estero Boulevard rehab project. It says written report only. So
Yes, Mr. Mayor, the clerk this morning updated the written report that's in your kit with a bullet from further, more timely update from K. Moeller.
yes.
With respect to the outfalls at Santa Maria Condos, area of Bay Beach Lane, Linnell, Redfish, and Tarpon Road. So that's the update on that. I can mention at this point, although not directly related to Pressure Estero project, but our discussions with regard to the foot of the bridge, the FDOT has assumed responsibility for the design and construction of that plan that was by council. They have worked with the MPO to assemble the funding for the project. The project itself won't implemented for until at least one, but DOT indicated it's their intention to add it on to the design work to the existing consultant they have working on the bridge.
That's all good news. Yes?
Yeah. Yes.
Okay, good.
I just had a quick question on that. I had asked Commissioner Sandelli to see if the county could come in and brief the new members, just give an overview of what the foot of the bridge project looks like. I watched the council meeting at the time, and he apparently had talked to the staff and said at some point that they'd be happy to do that. So when it's convenient, it'd be great to.
I've had that conversation with them. Well, both with Commissioner Sandelli and with the staff. They're trying to find a meeting that they can get here to do that for. It may not necessarily be an MMP meeting.
It's fine.
But they're trying to find an opening in their calendars to do it.
Be great. Thank you.
Do you have any questions or comments about the?
You said that they're planning 2021?
Yes. Which has always been the date for that, which was basically to complete our Boulevard project and then come back and do that. And then that's when Lee County was thinking about perhaps being the construction manager. But after conversations between Lee County and FDOT, the most efficient way to funding and for design was for FDOT to.
I assume, Roger, too, you're looking at this globally with respect to Times Square renovation, with respect to Margaritaville. So all these wonderful concepts could work in concert with one another as best possible, as humanly possible.
Yes. The short answer is yes.
That's a good answer.
Challenge, yeah.
Clearly, we now have 4 projects potentially slated for that area. 1 private, town, now the foot of the bridge slated for that area. Try to work to minimize means, but there can be some overlap and a different.
It's a nice problem to have.
Busy.
So it doesn't all happen in season.
Okay. Move on. Go to the next item, which is the Lee County Estero Boulevard Landscaping Interlocal Agreement.
Mr. Mayor, I have previously advised council that Lee County, to hearing some of the priorities of the town council with respect to the landscaping out there, thought it might just be best for the town to assume the responsibility for the landscaping. That's both in terms of installation and maintenance. We had the discussions, the amount of money kind of got settled in because that's what they had budgeted, and I think I shared with you all the rationale for that amount of money. The issue of the words was, that we were working on with them, was with respect to where we wanted to plant perhaps things more than they would have typically allowed. So we deal with that. We felt there were opportunities for enhanced landscaping. And what the agreement says is that you have to notify them, but we can do it. Not only do we have to maintain it, which we would have to maintain any landscaping we put in an agreement, but you'd also have to assume liability if there were an accident, the person alleged that that enhanced landscaping contributed to the accident. So those will be decisions you'll make as the design of the landscaping occurs. We'll show it to you. We'll show you where it falls within the Lee County spectrum of risk, and you can decide whether you want to go for a lesser design or a more enhanced design with more landscaping at that particular period of time. The agreement is flexible to allow us to do that, and if this proposed language is acceptable to you all, on the agenda, you'll approve it. It will go to the county commission for approval. The funds will get transferred, and then we'll begin to work on implementation. And most of the landscaping opportunities are at the south end of the island. There's not a whole lot of room on the parts of the project that have been completed to date. The only real change there would be to go from sort of that highway type of grass to a more, Augustine or something like that. Appropriate.
I've many times expressed my desire that we'd use some kind of native ground cover rather than grass, because the grass doesn't get cut and it's unacceptable, whereas the native ground covers are being used in Fort Myers. If you go downtown, you can see them.
To your point, Vice Mayor, these areas do not have irrigation. We need to use Florida native to the greatest extent possible. Perennial peanut is a typical ground cover that's used in many, many locations in lieu of sod. And clearly, we'll talk to the company, landscaping company we're dealing with, to see where that would fit and be appropriate. So there's some, in the existing areas, there's some very, 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 very small areas. I just don't even know that perennial peanut would work in something that's small, because there's room to work based on what I know about it. But we'll seek the opinion of the expert and apply that to the greatest extent possible. But all those designs in terms of ground cover, bushes or trees and any of that stuff will be presented to council. We'll probably come up with, I'm going to say, somewhere between 3 or 4 alternatives based on the size and length of the available planting area. And as you bless those sort of schemes, they'll be repeated throughout the island where appropriate, kind of the way we're envisioning.
I have to say, I'm really excited that we're going that direction and have more control over how our island will look.
Whose idea was it to not have the concrete go all the way out to the, is there a reason why the concrete didn't go all the way out and we have that little stretch of grass that is between the curb and the sidewalk? Is that just an aesthetic reason, or?
Water?
I'm not sure. I wasn't here at the time when that was designed, so I'm not really sure all the reasons that they may have been considering for that. I think that there are some small areas. I don't know if they were originally designed to be places for mailboxes. I don't know if they were designed for flow, for the sidewalk flow to those areas. Aesthetics was a driving decision-making factor in the county's design team's mind with regard to those smaller areas.
It's also a safety issue. Sidewalk has to end somewhere, then there has to be a delineation before the road. In other words, if you're going down, you're walking, swing out, you're going to be in the road, or if you're riding a bike, which you're not supposed to be, but you swing out, you're in the road. This breaks it. It's a break between the sidewalk and the road.
Also, I'll tell you, living on Estero, that we have one of those little grass strips, and they come through and they mow them pretty regularly. But our mailbox, there's a Mound House sign there. Our next door neighbor, they have, it's kind of a house, and the whole thing is driveway. They had a heck of a time putting their mailbox in, all concrete.
I'm glad you brought up the mailbox. Talking about liability, who's liable for the mailboxes? Further down, I don't know if you've noticed that the mailboxes are in the concrete.
Yep.
Turn sideways right at the curb.
Black.
And that's a disaster waiting to happen. Someone's gonna run into that. Is that covered at all in here with the landscaping?
Well, no, that's not part of this agreement. That's county's design, and my understanding is that those mailboxes are frangible from a vehicle perspective. I don't know from a bicyclist perspective or someone just walking down the street not paying attention perspective. I've never seen anything like that in my career, I can tell you that.
I was dumbfounded when I saw it.
But apparently, I don't know if it was planned or unplanned, but, clearly they had to provide space for people to have their mail delivered, and that's what they came up with.
You can just see a potential problem. Maybe I'm wrong. Maybe John, you can opine on this. That is there going to be an issue with the town? I mean, I know it's a county road, but
Well,
did
they're not.
litigation ever come about?
The agreement in question is purely for the landscaping. That's all we're assuming responsibility and potentially liability for. Anything else that the county has put within its right-of-way or allowed to be put in its right-of-way, it's responsible for, not the town. That, I'd be straight up if I were not to tell you that if someone gets injured, the natural reaction is to include the town in any subsequent claim. Those generally are always covered by our League of Insurance coverage, and an outside law firm is assigned, and we immediately notify both the league as well as the assigned law firm that the area in question is actually under the jurisdiction of the county. And since I've been your town attorney, I can tell you of at least 3 lawsuits that either we've received notice of, the pre-suit notice, or actually been filed where the town has been named. We have asserted, or the League of Cities Attorneys have asserted on our behalf, hey, this isn't our responsibility, we're not liable, this is the county right away.
Okay, so is it the consensus of the council here to authorize the town attorney and town manager to bring this interlocal agreement forward and execute?
I have some reservations, and I understand, and I agree that, I don't really like the grass they put in, although that's a really long, narrow strip. You could put native ground cover, there would be maintenance. I know that, this lump sum covers the maintenance in perpetuity, and, perpetuity is a long time. It looks, and, anything like any kind of significant vegetation you couldn't put in that strip. So the first northern part of the Estero, there's nothing green. Second, it's a pretty small strip, and we see the guys come by, when they're getting it ready, they came by with a water truck, watered it, and they come by and mow it, and it's a long strip to mow. I don't know how much of expense that is, or if the town has the capability of that kind of mowing. If they had special equipment for it.
Bill, if I could, I've talked to staff in the past, because Roger knows I'll go out and ride with people and do different things. A lot of times, we've mowed Estero Boulevard in the past because the county wasn't mowing it frequently enough. So we end up taking up their slack anyway.
I know my wife loves her native plants, and she's loved to put something in that stretch in front of us. I have lived in places where where they have a parking strip, the area between the sidewalk and the curb, and that's the resident's responsibility.
Bring up a good point. Will the residents have places like yours, Bill? Will the residents have any say, other than through public comment, on what potentially would get put in front of their house?
That would be up to you how much, input you like to give them. I think part of the problem may be that the real planting opportunities are part of the project that's still deep in construction. It's not really the areas that they've completed. So these plantings, for the most part, would be going in on the southern part of the island, from the church beyond, not really in the areas north of the church. So that's that. With regard to can the staff do it? The answer is, well, we would have to buy, we have vehicles, we'd have to buy a water tank attachment for our vehicle to, help the establishment of those plants that need extra water to be established. Typically, we would try to pick plants that once they were established, they would thrive fine on their own, wouldn't necessarily require watering, except in extreme droughts. And as pertains, we'll have to buy some things, we'll have to buy weed eaters and some other things that maintain those plants that we choose to put in, and that's part of the plant selection process. So do you pick plant A that they have a tendency to grow outward, but it's very pretty, require a lot more maintenance, versus a plant that's narrow and would just tend to grow straight up, may not be as pretty. So that'll be part of that discussion. And then, whether the council wants to get to the point where if we were to plant in front of Mrs. Jones's house, that Mrs. Jones says, I don't want it, that we don't do it. And that's all something, all can consider as we get further down the road.
I'd suggest everybody take a ride down to Naples sometime and just go through the neighborhoods down there and see the different plantings around. You'll get a good idea of what's out there. Okay. Your questions answered, Bill? Or?
I would like, as part of this, before we jump into this, I would like to know what the vegetation plan would be. And I understand, I'm looking right now at the right-of-way for the 80, down where it's 80 foot, and it does look like they have, the turn lane, travel lane, bike lane. There's the parking strip sod and the sidewalk, which has a storm drain underneath it, and then a bit of a berm. And the only place I could see you could put probably significant vegetation would be on the outside of that sidewalk.
Well, notwithstanding points that you made, Counselor, clearly, to the extent that the council decides that those opportunities down the road are far few between, the number may look more attractive or not for those areas that might be your colleagues are comfortable. So, based on our analysis of the number, if we were to plant what the county originally anticipated, it would be roughly half of the installation, half of the maintenance activity. Judge and cast your vote based on that, as well as the other points that you made. The real question is, do we put this before the council for a decision, or basically tell the county council has thought the issue?
Yes, to me, it's a no-brainer that we want to have control of this project. I mean, Dan brings up having input from citizens about this, and we as a council have given input to the county about what's been done so far. We've been completely ignored. So if we want to have any control over this, we take it. They're giving us the opportunity, and I would say we should grab it.
I agree. The only question is, where did the 820,000 come from?
I believe I had sent the council and it was a while ago when I told you about the number and the counties and that, back up to the number. We can resend it as part
I just don't recall off the top of my head.
the item packet, should this move forward.
Right. Well, the direction is move forward? Okay,
Okay, so we'll work to put this on upcoming agenda for the council's approval.
thank you. The next item is building department permit fees. Roger, you're on a roll.
Okay, thank you, sir. As part of our annual budget process, we always try to do sort of a deep dive into one subject matter or another that we don't necessarily analyze in depth every year just because of a lot, inability to tackle everything at the same time. And our target project this year was to take a deep dive into our building permit fees, and I've heard comments from the council since we took over the building function about the desire to be timely in our plan reviews and building services, to sort of look at that whole issue holistically. So with that, I had tasked our services administrator and the building official to literally go through 3 years worth of permits, one by one, analyzing the fees and costs. And what they reported back to me was that that some of our fees needed to be tweaked, just due to the relationship between staff time and costs and inflation, if you want to call it that, or whatever, and the amounts we were charging, which we basically just picked up Lee County's amounts, put them forward. But more importantly, what they said was the way we are calculating fees was extremely staff intensive. Had a great propensity, because it was intensive by using a square foot rate, to staff errors. Made it extremely difficult for contractors to be able to meet with a potential client and say, hey, based on your talent, you want me to do your kitchen? I could tell you that the building fee is going to be X, Y, Z. They couldn't tell their clients what they potentially could be. They would have to wait and sort of do it as an add-on back at a later date and tell the client, well, here's the bad news, the building fees are X. And that, in some cases, created a little bit of animosity because it's never what the person anticipated it would be. Created a scenario whereby if we were going to try to do the gold standard of building services, which I mentioned to the council at a previous date, where if we can't deliver, that we could get some of the fees, residential properties in particular. For all those reasons, and if nothing else, to get our fee schedule for building services down from, I don't know, 20 pages to 6. We basically said that, look, does it really matter if your house is 1,501 feet versus 1,500 feet? Probably not. Now, the effort between 300 feet and 1,500 feet is about the same. So you have to have the same staff looking at it. But there's definitely, in our belief, an opportunity to be able to say that, set up a flat fee for a certain range. We know what the reviews are based on their analysis, and they know how much effort it takes for each sort of size of a house, if you will, the smaller house, medium-sized house, and a house, if you will. So that's what Jack and Daphne did. We believe that it's an innovative and effective way to go forward. We'll address those few issues where we weren't collecting enough money. We did another thing, we just rounded some of them up just to get, so someone's permit wasn't $20.17. We get everything on a $25 basis just to make things easier for efficient purpose. Or, you know, if the council's so inclined, we can kind of stick with the methodology we're currently using and surgically go in there and tweak for, I don't know, stormwater review by 10.
Questions for the manager?
Mr. Mayor, if I could, Roger, no, it's a little bit apples and oranges, but when I was insurance commissioner in Indiana, we had a dynamic where the industry came to the Department of Insurance and said, we would be willing to pay more in fees if we knew those fees were dedicated to better service for our companies in terms of quicker turnaround, more responsive, et cetera, and it didn't go to subsidize the general fund. It'll be actually to actually assist in the permitting process, if you will, in your case. Our case was rates and forms. So I think the model is good, assuming that for this increase in fees, it does go specifically to that department, which it sounds like it does. Is that correct?
Well, first of all, we're mandated by state law to do that, but even if we weren't, I agree wholeheartedly with what you're saying, and that is that the users should get the benefit of the rates, and that necessarily, you know, any surplus monies or whatever that were generated shouldn't necessarily.
I guess the only thing that it may not be missing, you may just not have elaborated on it, is that the thing that appears to be missing is that have these specific recommendations been vetted with the building community, the folks who most often use our services? Because I think, not that they should have veto power over these things, but I think they should have input. There may be things that specifically they need for streamlining, for expediting. There may be a process or two that needs tweaking. And it seems like if there was an ad hoc group of users who could review these and then sort of say, listen, nobody likes a fee increase, but hey, we're going to see some real benefits in the department in terms of expediting process or just simplifying things. And they could put maybe some sort of a stamp on it of approval. Then at least the users would be in concert with the fee increases. May not be thrilled with them, but at least they'd understand them and have some input into them. Has that happened, or is there an opportunity for that to happen before it comes back to us?
Well, let me say this about that. You know, my experience is that the approach that we're taking here, that's for the end user. That's for you to determine who that is. I believe the end user is the person whose property is being improved. You know, we don't want to do anything necessarily to be detrimental to the contracting community, but I want to make sure, you know, you say to us, who's our primary person who we're trying to protect? That's who we're trying to protect. And I believe that their ability to tie a flat fee to a scope of work will be a lot simpler under this proposal. There'll be less of a motivation to try to slip something in under the wire, if you will. That's not permitted or otherwise, perhaps try to skew the square footage or any of the other factors that calculate. Be a much more above board, transparent system for everybody. And moreover,
Pass through.
well, but it is, sir. It is. That is exactly right. But I want to really help you understand. The increases are really minor in nature, in my opinion. They're just little changes where the rate and the effort to provide that element of the service were not aligned. And you don't want the inverse thing to happen that you were concerned about, Counselor, which is the general fund going to augment the building services department? These rates need to be adjusted. For that reason, I have that concern, which I do. So we want the building services department to stand on its own 2 feet. The question is, we continue with the way we've been providing that service, which is you submit information from us, we analyze it and we tell you back how much the permit should be, or before you walk through the front door of Town Hall, you know what the permit fee is going to be. That does a couple of things. It's a situation where people don't apply for a permit, we do all the work, and maybe that project doesn't get built, and we've done all this work and it doesn't get built, and we get zero for it. It creates a scenario whereas we don't have to be concerned about whether a contractor inadvertently left something out when they submit it to us. So it really does close a lot of loopholes, and I believe make things better for the end user. Since they get a quote for the job, how much does it cost to redo my kitchen or bathroom or whatever, contractor will be able to tell me, and by the way, the permit fee is going to be X. They can tell them right what it's going to be right then and there on a residential property.
I appreciate everything you're saying. All I'm suggesting or asking is, could we find 5 or 10 good actors in the contracting community, just run it by them and get their input? Maybe that's been done. It seems like seem like great ideas from our perspective in terms of government. I just think it'd be nice to marriage that with the people that have to utilize these fees and processes, just to get their input, because they might have some good ideas for us.
Well, the answer is, if that's what the council would like us to do, of course, that's what we'll do.
Doesn't that just make sense, though, just to sort of get input from the folks you're working with? It's in a cooperative, sort of a team cooperative effort?
Well, I can tell you that I've adjusted building fees, I don't know, 7 times in my career. I can tell you that contractors never wanted to change the fee. But we could try it the 8th time, it's okay. I have no objection to do that.
I just thought maybe they've got some ideas in terms of ways that things could be improved process-wise. And I'm not arguing that they should have veto authority, but it just seems like that would be wise to run it by the people
Well, we
who
could
use
put the
our
proposal, we
services.
could put no, if the council thinks this is aerodynamic, and the information out to the contractors, and what comments we get back, and then decide whether we have, a meeting would be appropriate or not.
I have an idea, just to simplify the whole thing. Put a notice somehow to the contractors as they're applying in the next month or so that says, this is under review. If you have comments, contact Roger Hernstadt.
I think that's a great
That
idea.
invites them, but we don't have to set up a meeting, we don't have to, because I don't think he's going to get a lot of feedback personally, but we could put the invite out there to everybody who applies for a permit within the next month or whatever, and let them know that we welcome their feedback.
I think that's a great idea. I would just say, as a new counselor, I've already gotten wide variety of feedback from contractors that either, by the way, I don't know if Jack is here, I just got a wonderful comment, a long call from someone who's had real consternation with the town, had an awesome experience with the permitting process, so kudos to you, Jack. But I'm just saying, I think that's a great idea, Counselor, and I would be supportive of that. It's just always good to work in concert with the people that we're regulating as best we can. I know we won't agree on everything, but to give them a heads up, here's what it is, here's your chance to have some input, just seems like a cooperative process. So I would be comfortable with that if that works procedurally for you. Yeah.
And Jim, I can tell you, as a former contractor and someone that deals with contractors every single day, I hear a lot of the same things that you hear. I can tell you, contractors, the most important thing to them is streamline, and time is money. As the mayor alluded to, it's a pass-through. These fees are going to get passed through to the homeowner or to the association or to whoever they're dealing with. And I don't think it's as big of an issue, and I'm just speaking for myself. When I was contracting, the fee wasn't as much of an issue as streamlining and getting it done, knowing when you fill out a quote for a customer, knowing exactly what that fee is going to be as opposed to, percentages and this and that, and knowing what it is up front. The homeowner knows it up front, and now with this, 3-week time period that they know that they're going to have a permit coming back. These are all good things that I think most contractors, if you ask them, will be in favor of. And I have spoken to several excellent contractors who refuse to do work on the beach simply because the permitting process is very tedious. It's unknown. I think this would eliminate some of that and hopefully bring some of the excellent contractors back to the beach to work.
Yeah, please don't misunderstand. I commend you, Roger, and the staff for doing what you're doing. I'm just saying, can we bounce it off some of the users just to see if there's any additional ideas? We might learn something in that process and get some good input. So, but your point is well taken, Dan.
Counselor, I will tell you that in my time here, I find it's I haven't had a secret that was kept yet. So I mean, clearly, so this will be out in the contracting community, and I'm sure to the extent that we'll make sure if they don't hear it by word of mouth, they see it when through announcements that we'll make, and we welcome their input. We're always looking if there's a way to make a product a better product. We welcome it.
Good.
As you say, just by virtue of us discussing it today, the word will be out.
Which is one of the reasons why we put it on the M&P agenda, to
Exactly.
start that process of it getting reported in the media, and so on and so forth, so that people can begin to share their thoughts, not only with us, staff, but with you all as well.
Okay, well, I think it's a good analysis that was done by the staff, and I commend you for that. I think if you could pick up one or two of these a year, as you say, in the budget process, it's very helpful for everyone. Yes, sir.
What kind of percentage increase is this on the?
5 to 7.
So from reading these numbers, it seems like that you think you're undercharging for commercial. There's more work in commercial than, a lot of the rates are pretty trivial, if anything.
It's not the amount of work, it's the amount of effort to review set of plans, say, for commercial versus a duplex versus a single-family home versus a renovation. That's what we're looking at. And what we discovered was the universe of commercial was too complex to try to set a flat rate for that. We just tweaked the individual elements where we felt that the effort it took to plan review and inspections for that element was not commensurate with the amount we're collecting. But we were able, in terms of the residential units, on multifamily, to be able to get a pretty good categorization and able to put them in a silo of categories of work. And that's why we were able to develop a flat fee for those. By the way, this is innovative. But I think Jack would tell you if he was at the microphone that he had his reservations about this at first. But I felt that value of, as Councilor Hallis was saying, the value of contractor, not only be able to quote you the price for the job, but quote you the permit fee, was a tremendous step forward. Because I don't care who you are, no one likes that surprise. You think, because you put in your mind, the price of the job is what the contractor told you was the price of the job. And then, and say, and by the way, it's X number of dollars more. And that always is important.
Change orders, we call those.
Yes, nobody likes change orders.
So I think us being able to say, hey, here's a rate. And by the way, there's no advantage to try to sort of cut corners or round edges or whatever, because the rate's the rate, whether you do it or not. So no advantage for you to even think about doing that.
I think, as far as this goes, it seems like, to me, it's pretty straightforward. I think what you're talking about, Holt, is that, the whole process of permitting. And it's a complicated interchange. I like to think that the contractor submitted a design, it's reviewed, it's approved, et cetera, et cetera. But my experience a lot of times is there's multiple iterations of a permit or plans going in, having a problem going back, having to go back to the contractor, architect, back and forth. And that creates a much more complicated process, and plans were ready to go. So there's contractor responsibilities to make things go smoothly, as well as the towns. And then maybe the idea of some kind of roundtable with, like you said, an active group of contractors and the towns to have an open discussion about see the situation from each other's perspective. I think that would be a good.
I will say this. Doesn't happen very often, but occasionally I'll get a call or an email and someone said, well, I always hear there's all these issues. Why wasn't there, I got my permit like yesterday. Well, it's possible. I always hear about all these issues. So it really comes down to who your contractor or designer is. And in particular, when they submit something and we give them comments, whether they decide they want to argue the comments with us or try to design around the comments we gave them, or just say, that's what you're looking for, that's what we're going to give you. Ones who say, that's what you're looking for, that's what we're going to give you, they generally, as a rule, don't have problems getting there. Who want to look for alternatives, who try to work around those comments, that will add a lot of time to the process. It means that their next submittal is basically the same as it.
Very good, thank you. We'll move on. Next item is the review of the draft ordinance. Thank you for your assistance in those matters, staff members. And 20-12, which is a state of emergency and disaster planning.
Mr. Mayor, members of the council, you may or may not recall that at a prior meeting where the council was dealing with COVID-19 related issues, the vice mayor pointed out some internal inconsistencies and duplication of language in our code with respect to the declaration of emergencies and things of that nature, and the process by which the town declares emergencies and takes action in furtherance of cleanup and other items. So this ordinance is a cleanup of that prior regulations. We've taken out the duplicate language. We've consolidated it because it was put out in various articles. We put it in just one article. And to the issue of kind of what we've been dealing with recently is that it was not clear in the prior version or the existing version of the code, the declarations of local emergency that are local versus statewide, which is, for example, the COVID-19 pandemic. The governor's entered an executive order that's stating that the emergency is statewide. When an emergency is statewide, then the emergency is for the time by which the governor has declared. Whereas if it's a local state of emergency, either locally established or by the governor, it has to be renewed in 7-day increments. So we've made that distinction, and also clearly specified in the code that particularly with respect to when there are statewide emergencies, the council always has the authority to enter emergency declarations consistent with state statute, which we've done some in the past with regard to the COVID-19 pandemic. Otherwise, here to answer any questions about any specific provisions that you may have a question or concern about.
Questions?
I don't have a question, but just for the benefit of my fellow council members, I think you're going to see several ordinances coming through in the future with these similar problems. Apparently, we had a period of time where the town attorney would bring forth ordinances, but not take out the old info that was duplicative. And it seems like every time I look at one of them, I'm finding we have, and special events is one that's going to be coming to you. I think I found 6 different definitions of special events in our code. We weren't taking out stuff. So this is not the only time we're going to be doing this. There's going to be others where you're finding we're fixing things.
Another specific example of where that's, we've already done that is when we updated the boating regulations. Those regulations were strewn across, I think, 6 different chapters of the code. So when we redid them, we've consolidated them and put them all in one place. So you don't have to hunt to see what section of the code you're relying upon, and to the extent that there actually may be duplication. So yes, that is an ongoing effort that we are undertaking. I don't know if at this point you want to, since we're talking about ordinances, if you want to take up the draft nuisance abatement ordinance that I distributed and that we've discussed in the past. It is in draft form. It is substantially similar to the Lee County Nuisance Abatement Board language. I previously forwarded to you, I gave you a number of different examples. The reason why that I used the Lee County one, frankly, is because it's already written to interface with the Lee County Sheriff's Office. And so that's the primary reason why we've used the county version, obviously customized to the town, change the language where appropriate, but otherwise that's the base document that we're working off of. I have had some communications with the Lee County Sheriff's Office Legal Department. They are favor this version, again, because of their familiarity and the interface with it. Certainly, it's a work in progress, so if there are any particular provisions or questions that you may have, certainly we can address it, but the basic concept is, do we have council direction to move forward to place this on the agenda for first reading? The last one final comment that I will mention about this particular ordinance that I'm still trying to clarify, particularly with Lee County Attorney's Office, which I'm going to try and reach out to them today. I already had these conversations with the Lee County Sheriff's Office Legal Department. Is if you look at the state statute, it talks about four very specific categories in which the nuisance abatement board has jurisdiction over. The Lee County ordinance actually includes 2 additional areas or categories that are not in the state statute. So, I think that the county, is taking advantage potentially of their home rule powers under their charter to expand to include 2 additional areas. But I do want to check with both the county and with the sheriff's office to make sure that we're all comfortable with leaving that language in. And it deals with illegal sale of alcohol and
Behavior. Food behavior.
lewd and lascivious behavior. Those are the 2.
That was actually the question I was going to ask, John. If we're doing this pursuant to an enabling statute from the state, what authority do we have to add things to it? How could that be enforceable if it's not part of the state enabling statute?
That's the question that I want to, if the county is aware of something that I'm not, that's the inquiry. But I just want to give you all, the reason I mentioned it is, as you indicate, Vice Mayor, that may end up having to come out because my view is we only have the ability to put in and give our nuisance abatement board jurisdiction over those items that the legislature has identified that that we have the power to regulate.
Certainly like to have the answer to that question.
I will have that answer before first reading.
Because if you take that out, which I think we probably would have to do, it really doesn't help us much, in my opinion.
To compound that issue with respect to the illegal sale of alcohol, one of the remedies is to suspend that license, and those licenses are actually issued by the state, not by us locally. We have zoning approval, and to the extent that someone may not be in compliance with the zoning approvals, we have independent authority to take action on the enforcement of those zoning approvals, but to revoke the actual presumptive state license, I don't believe we have the ability or that we can give a nuisance abatement board that authority. So those are questions that I have, and I will find the answers out to how the county believes that those issues are appropriate. Because in my conversation so far with the Lee County Sheriff's Office Legal Department, they're like, yeah, gosh, you're right. So I will provide you with a further update, assuming you direct me to move forward with this ordinance.
Discussing item 5 in the list. Illegal sale and consumption of alcohol.
Yes, yes. On a related note, just to fill you in with discussions that I had with Roger, I noticed that the Lee County ordinance for their board provided that municipalities could do an interlocal agreement with them and therefore not have to do their own board, which excited me that we could use theirs. I was hoping that we could. Roger followed up on that and learned that their board is apparently completely inactive. which leads me to question if in the entire Lee County, there are not enough nuisances occurring that their board is even active and hasn't been active, as far as we can tell, for years. How beneficial would this be for us? I agree we have a problem, but I'm not sure this is the way to attack it based on what I'm hearing in several different ways.
Well, Fort Myers had one. They actually were able to use it quite successfully. Cape Coral currently has one.
I'm aware of all those, but Lee County is a lot bigger than all of those, and their board isn't active at all, as far as we can ascertain.
Very true, but, you know, to go back to your comment about you're not sure how this will, you know, that this will help us, although that may be out to be true, one thing that is true right now is how could it hurt us?
Well, we're going to have to set up an entire bureaucracy
Certainly.
for this. So it's going to take time and money. And like I said, I agree we have a problem. I'm not saying I'm against this. I'm just saying I'm not sure at this point, especially if we have to leave out item 5. Is it very useful to us? So that's all I'm saying. I'm not saying I would vote against it. I'm just saying.
And while we're on that point, I'm struggling as to why this wouldn't be helpful to us. Could you walk us through these first 4 items? We can discuss 5 and 6 later, but with respect to, it says if the nuisance, and this is helpful to people who are listening who think that this, because obviously the term nuisance abatement board sounds very broad. But according to state statute, it's actually pretty narrow in terms of its jurisdiction. So I want folks to be in fear that the nuisance abatement board is going to, you know, send you a ticket because you didn't sweep your sidewalk. I mean, it's very restrictive. And let's go through these because I'm curious as to your interpretation, John. It says if the nuisance abatement board, this is item H, if the nuisance abatement board finds that on more than 2 occasions, place or premise was the site of an unlawful sale or delivery of a controlled substances. Obviously, there's a proliferation of illegal drug use on this island. So is that, do you see this as would that have to be a conviction? Have to have already occurred to be cited, or an arrest, or how does it work from a practical standpoint?
I see Councilmember Beach smiling over there because he and I had this conversation independent of morning. It is just simply that there's been documented sales. No, it doesn't necessarily have to be a conviction, but from a evidentiary standpoint, that certainly would be better. However, the problem with essentially waiting for the disposition of the criminal case is that, waiting. You know, we don't have control over the state attorney's office and the court system and how quick or slow they may process a criminal indictment or charge. And so the nuisance abatement board is set up and designed to work independent of the criminal justice system. It is an administrative process. So if the evidence is that there were the sale of or delivery of a controlled substance on more than 2 occasions with a 6-month period, and those are the allegations, is that the proof, then that's what would be brought before the nuisance abatement board.
Has it been your experience, I know this isn't really your daily but it's certainly fair to say that the delivery or sale or delivery of controlled substances on this island is not rare. Is that fair?
Not rare anywhere.
I'm just saying
I'm
saying that because to illustrate the point that this really could have it. But when we say that Lee County is dormant, they're not doing anything. Well, that's their choice. I mean, if we have an active council and an active nuisance abatement board, we could be very constructive in utilizing this again when appropriate. It's a question of will. I think it's not a question of whether it works or not. And so I just don't want to be too dismissive of this idea. I think, again, it's where I talked to the former chair of the Fort Myers Nuisance Abatement Board, and he said it was when it was active, it was very useful. They shut down a place, they find places, they've changed behavior. And again, I hope we never have to use this. But to dismiss this as not useful, I think is a little unfair at this point.
My understanding of the nuisance abatement statute and my experiences in the past, and I have had, I have had experience with nuisance abatement boards in the past, is this language, subsection 1, in the ordinance as well as in state statute, came about primarily to address what was very prevalent in the 80s and certainly the early 90s, what are commonly referred to today or back then as crack houses, where, areas of municipalities were being overrun and rentals and houses were being turned into, crack houses for the sale and consumption. And one of the ways to address this from a administrative standpoint and a non-criminal standpoint was to give establish a nuisance abatement board and give that nuisance abatement board that power. So any location that meets the criteria and can be documented is potentially the subject of a complaint to be filed with the nuisance abatement board.
Moving, if I can, if you are serious about this and you want to go forward with it, then I would say that the total fine that we have at the bottom of the page toward the end of $5,000 is ridiculous, because there are businesses who would just absorb that as the cost of business.
I see, I agree with you 100%. And
So-
my question is that dictated by state statute, or do we have flexibility there?
What Lee County did with respect to the costs and fines is they took the language out of state statute, not in the nuisance abatement, actually in the code enforcement, which says that a first-time violation of a code provision, and this technically would be a code provision, is punishable for a fine of up to $250 a day for each day that the violation continues past the nuisance abatement order, $500 a day for a repeat violation, and up to a $5,000 fine for a irreversible, non-remedied, habitual offender. To the point of the vice mayor and to all of you is the $5,000 component, which essentially is a third violation or more, can be assessed for each incident of the violation. So every time that it occurs and can be documented, the nuisance abatement board finds that occurs. I read this language, I interpret it to mean that it would be up to $5,000 a day for each incident of violation.
I
I
don't
also
think
might
that's
point-
clear.
I also might point out that it seems to me when I read this, that that's only part of the enforcement. The other enforcement is being able to close down all or part of the operations.
That can be modified, as the vice mayor points, because it does say in the county version that the total fines cannot exceed $5,000. The fine imposition, I would point out, is in fact independent of other remedial action that the nuisance abatement board can order, which is also set forth in the ordinance, the draft ordinance. Can order the activity to stop. They can order, I've seen incidents where, or situations where a nuisance abatement board has ordered owner of a commercial piece of property to have a police officer, law enforcement officer on watch during certain hours, that, again, that the business has to then shut down after a certain point. And the extreme remedy that the nuisance abatement board has is that upon a determination of a nuisance that essentially is habitual nature, they can actually order the business to be shut down.
Where is that in the language? I'm not disagreeing, I just
Just
wasn't.
above from the, where the fees are, it's 2 sections above section 3.
John, if I may chime in here, the reason that I've been so supportive of this particular one of all of the ones that you have sent to us is in my communications with the Lee County Sheriff's Office and with Lee County, this is the one, as you said earlier, that the Lee County Sheriff's Office has been in contact with the most. They're the ones that have had input into it that allows them to do their job to their fullest extent. As they mentioned to us here on Monday, having this in place does give them a little more actionable things that they can take.
That is correct. If you look on page 5 of the ordinance, and I apologize for the pages not being numbered, section initiation of proceedings, subsection A specifically identifies the Lee County Sheriff's Office Nuisance Abatement Coordinator, which is their in-house department that's responsible for administering their activities as it interfaces with our nuisance abatement board, if you were to move forward with this and create one. So there is that built-in compatibility, merger of our resources and the sheriff's office's resources, and that they're obviously familiar with doing so because it's been provided for in the past for them to do this.
And am I correct in reading this, the way that I think I interpret it is complaints would go through the Lee County Sheriff's Office
Yes.
before
and-
going to the nuisance
Yes,
abatement
and
board?
they, we would, the nuisance abatement board, the clerk and the town attorney would coordinate with them, sending out the proper notices and making sure that the hearings are properly advertised and take place. But as it's currently written, it would primarily be the responsibility of the sheriff's office to provide the evidentiary material backup and present the case to the nuisance abatement board, demonstrate that a nuisance does exist and ask for any of these remedial actions available to the nuisance abatement board that they get implemented.
John, would you be the person presenting the case for us?
The sheriff, we would interact with the sheriff's office as it's currently written. This ordinance provides that I would be the attorney advising the nuisance abatement board, but that can be easily changed to say that I'm the one presenting the cases. In my conversation, and my understanding is that it would be the sheriff's office that would be bringing the cases forward on behalf of the itself and any other complainant that's a member of the public.
Well, if they're doing it, then I've got to believe they're going to be charging us for that service.
Haven't had that conversation as of yet, but it's a possibility.
And going back to my comment about the 5,000, I would say it should be at least $25,000 as a, 5,000 is nothing to the.
I think it depends on kind of the scale of what you're talking about, because, and I've read some of the, someone sent me a summary which had some case on this, and, you know, I mean, so the way I understand this process would go, right, is if someone complains to the abatement coordinator, to the sheriff, they would determine whether or not there's justification to go forward and bring this in front of them. The board could potentially close down, let's say there's a small hotel that is doing a lot of drug activity. And, you know, these things a lot of times happen in these tests. And if the board decides to close down that entire premises, but it wasn't necessary to close down everything according to the rules, they could come back and charge they're being refused the full benefits of their property ownership. So there's a lot of pitfalls to it, but I think that the big part of it is forcing people to comply. I mean, the idea here is not necessarily to punish people, it's to get people in conformance. If there is a problem, to try to eliminate the problem.
I think the first thing that's going to happen when you try to shut somebody down is they're going to go straight to court, and we're going to have more attorney fees, a lot more cases.
Can I ask a question on that point, John? I'm on page 8 now, where it talks about, upon declaration, the nuisance abatement board may enter an order immediately prohibiting the maintenance of the nuisance, the operating or maintaining of the place or premises of, the conduct, operation, or maintenance of any business or activity on the premise which is conducive to such nuisance. And of course, the finding language is after that. So is it the discretion of the nuisance abatement board as to whether to initially start with fines and then potentially shut down the operation, or can they skip the fines? Is it totally at the discretion of the nuisance abatement board, or how does it work procedurally?
There is a certain amount of discretion available to the nuisance abatement board, just as, you know, for example, by comparison to our special magistrate. But historically, based upon the case law, I've seen it done this way by other jurisdictions and places where I've been involved in, that it's incremental. And the reason why is want to be able to some, at such point in time that the nuisance abatement board issues an order saying you're closed, and there's subsequent appeal and litigation related to that, it's always better to be in a position to show that in the record to the court that nuisance abatement board in the town bent over backwards to try and resolve the matter before it got to the point of shutting them down. So generally, it's incremental. Now, if there's just a new business that opens up and it's open and notorious and it requires immediate action, then certainly the nuisance abatement board would have the discretion to address that type of situation. Again, generally it's incremental for a number of different reasons. Sir.
This proposed ordinance would also pertain to residential property.
Any property,
Any
that's
property.
correct.
I'll tell you all a little story here. About 21 years ago, when I was last mayor of this august group here, I got a call one day from a friend of mine who lived down on the end of Egret Street, the Vice Mayor's Street, the other side of the street. And he said to me, "Ray, you got to help me." "Jamie, what's the matter?" "We have a crack house on our street." I said, "A crack house on Egret Street? Are you sure?" He says, "Ray, I'm from Miami. I know a crack house when I see a crack house." I said, "Okay." Well, I picked up the phone and called Matt Powell, who was our captain at the time. I said, "Matt, here's the address. This neighbor, next door neighbor, insists that there's crack being dealt out of this house every night. We'll check it out." They set up the next day, and sure enough, the parents of the house or whoever owned the house had left town for a couple of weeks, and the kids set up shop, and they were running crack in and out of that house every night, all night long. If you don't think it can happen anywhere. It doesn't have to be the bar down here or the restaurant down here. It can be in any neighborhood on this island. It opened my eyes, and that happened. So,
And that's a case where the sheriff's department should be taking action.
and they did, but I guess it would, if there was anything to be done in the future again, or if it reoccurred, and if there was an abatement board, I suppose, that could be brought to the abatement board and say, well, here's the prior history here, what's happened, and whatever recourse they take after that, I guess, would be pursued.
That's exactly the point there, Mayor. I'm glad you said that, because what you just said, Madam Vice Mayor, was, yes, they should be handling it, but this allows them to take it to the next level, to be able to actually shut that place down. You can keep going back and enforcing it over and over and over again. This gives the town and the residents something that they can do to make sure that it goes away.
And my response to this is, for all of the conservatives in the room, this is an action where you can take away somebody's property rights using a board of people that are not necessarily legally trained, and they don't even have to follow the rules of evidence. I mean, you are really stretching it when you go into one of these. The possibility for abuse is huge. Got to be really careful with this.
Maybe that's why they were used so infrequently in those various jurisdictions.
I guess, part of the discussion really is, because, we did talk when they were here to the sheriff about a tool that would be useful to them. And I see, like Dan said, if you have a location which has habitual activity, but you go through and they bust somebody, but there's numerous operators there, and those other operators are still around, and the property owner, for whatever reason, is either profiting from or negligent in it, what kind of tool can be used to try at that? I mean, I know of, and I don't know what the history is for law enforcement, I know of 2 examples of hotels, small hotels, that before they were bought by their current owners, where they told me that there was a lot of drug activity and even people coming after they bought the house and digging into fences and things and stash away. So a property like that, if this kind of tool could be useful, and I do support it. And I understand what you're saying, but people don't lose their legal rights because they can appeal. And a lot of the case law I read on this was that they did, especially early on the adoption of this. And the boards were cautious. They would go through, and there was one property they talked about, and they first prohibited them from renting like 7 of the rooms. I don't know what the number was. So they didn't say, okay, you're doing it wrong, shut it down. And closing a few of the rooms ended up in the Florida Supreme Court. So, property, there are a lot of laws that protect property owners, and the Nuisance Abatement Board does not operate outside the law because people do have the right to appeal.
Okay. I think you have your direction there. Okay, we'll move on. The next item is E, which is the special event permit applications. Roger?
So, we've received our first request for special event permits that would potentially generate gatherings where people might not be socially distanced or easily socially distanced. And we thought we would try to get ahead of this and have a discussion here today on if the council feels that to accept applications for special event permits and under what parameters feel comfortable with based on the current information that's available with respect to COVID-19 guidelines, et cetera. So there's really no structure for this other than for you to have, going to look at the 2 events. I know you're all familiar with them. And these are the first. I'm sure there'll be others down the road. But to the extent there's some criteria or policy that the council's implementing now, would be good for us to have that. When we receive these inquiries, we could tell the applicants what their status would likely be.
I'll start it off. I don't want to be the Grinch, but we've canceled all these special events to date, and conditions have not improved. Matter of fact, conditions have deteriorated since then. They've only gotten worse. So for us to be even discussing this kind of now is somewhat premature, I think. But here we are, we're discussing it. So my 2 cents for the matter is that until conditions improve significantly, I don't know how we can possibly put people together for any sizable special event. If you want to accept applications and review them and take the time to do that, I guess that's a debatable question. But just don't think at this point that where we are today, and the situation really is not going to improve. I don't think they're going to lift these recommendations. Really, I hate to say it, but until there's a vaccine that comes out, that's not on the immediate horizon here. So that's my 2 cents on that matter, and I'm willing to listen to what everybody else says.
I guess my opinion is that these events are outside, and we're allowing people to eat in restaurants. It seems safer to me than going inside to a restaurant and eating. I'd like to see that with events like this, that maybe we have some kind of restriction that they have to have someone in charge of keeping account of how many people are at the event and regulating that so that it doesn't get overcrowded.
The current constraints now, it's like 50 people or less.
I don't think there is a constraint right now.
There's a CDC guideline.
I mean, on the special events. I don't.
There's
I mean, I thought statewide there was, because they went from recommendation of 10 or fewer to, I thought, 50 or fewer. Didn't know that's been removed.
You know, let me back up on my comment. I'm sorry to interrupt. Just realized that we're only talking about these 2 items right here. I suppose we could regulate these to a degree if these were to be held outside, as far as requiring masks and that sort of thing, because you're going to put people on top of each other, possible. It'd be the same way as if you walked into Publix without a mask, you're going to be next to people, or you're going to be next to the cashiers or whatever. So I think with these two items, these farmer markets outside, if there were regulations set up, our own regulations set up where masks would be required and other precautions would be taken, then I wouldn't have a problem with these two. I was thinking more in general of the big gathering, the huge gatherings that we have, and not these two. So I backtrack on that.
I have heard discussion of someone would apply to have a wedding.
Again, outside, as far as I'm concerned.
Well, just to be clear, in that particular case, there's an outside and inside component, but the number of people I heard is 30. That would fall within. Now, whether that's a good idea, whether they would adhere to the council's policy that if you can't socially distance, you have to wear a mask. Those clearly,
That's the
clearly are issues to contend with.
Don't have a business owner stake following the rules.
I don't want to be sitting there policing somebody's wedding.
Oh, we don't want to be doing that, and frankly, these two illustrative events that are in your agenda kit, we don't really want to be policing that one either. So, if we're going to create some clear conditions, in advance of perhaps considering approving their application, to know.
I've been reading about some of these farmers markets across the country of things that they've been trying to do. And a lot of people are talking about doing hybrid type things where you can drive up. Many of the people I've noticed in going to the two that we're talking about specifically are routinely going every week. And they're usually routinely getting everything that they, the same week over and over and over again. So other places that I've read on, they've offered a drive-through lane where people can pull up, they can have their stuff brought to them from the vendors that are there, they can create their sale, and they can continue on their way. They don't have to actually get out of their car. Maybe that's something that the vendors are interested in doing, or maybe that we can try to put in place that they can offer that solution. Thought.
I do know during the height of the shutdown, that was actually one of the recommended ways. And we've done it too, where you pre-order, just go and pick up. Always having too much interaction with the people behind the counter. Because one of the real problems with any kind of operation like this is you have one person sitting behind a counter and then a parade of people coming by, and there's a lot of interaction between different people over a small area.
Like anything else, it's a social event too. They're not just going to pick up they're and to talk to people and socialize and so forth and so
There's the
on.
mozzarella tent.
Yeah, but if they wanted to consider something like that, that'd be fine too.
That part of the application where people write down what their plan is to maintain social distancing.
Yeah, I would think at a minimum.
I know one thing the town seemed to do with the jet ski vendors and whatnot is they had them submit a plan to the town saying this is what we're going to do. What I saw that was pretty effective, at least some.
That is correct, and we have put restrictions on them that are still in place. State social distancing, their activities are. We felt by putting certain conditions on them helped with them to facilitate social distancing. Our part to tamp down the spread of corona.
I agree with Bill that we should ask people to submit along with their application how they plan to do social distancing, crowd control, COVID things. And if they present us with a reasonable plan like this, the jet ski people, especially for the outside events, I'm in favor of allowing them.
I think important, Council Allers was saying about sort of the call ahead, ordering call ahead thing. That works when you're, when you're about a takeout meal or order for vegetables or fruits. So it doesn't necessarily facilitate that type of situation for selling wares or products or other things that are not really set up for that type of thing, where I do want apricot jam or I do want the Parmesan and mozzarella, but I don't know what I want. I just want to go there and browse. So then you get, some of these tables, as long as this table before me, and you can get 2 or 3 people waiting to interact with the vendor. If people are not wearing masks. But we can put it to them about not only the plan, but what types of businesses that would be there. Because some of them might require particular safeguards and others might not. Might be very well, could be a pick, go in an order and pick it up. Might be more of a browse, what do you have?
We're open to this then, that's what I'm hearing. Open to at least accepting the applications and doing them.
Yes.
Right.
So we'll reach out to these folks in particular and ask them for a plan, social distancing plan.
Maybe just make it part of the application.
Well, I'm assuming you want us to review the plan and make sure we feel that it's appropriate, and if we have any questions about it, bring it back to you all. Don't, and they insist that it is.
Okay. Next item is the fiscal year 21 contract employee.
So this is sort of a precursor to the employee contracts themselves that would potentially come in front of council in December. I usually try to provide council with an update of what I anticipate will be the contract employee need for the upcoming fiscal year. So really more informational, and it's an opportunity for the council to provide me with any input to the contracts themselves. This is really on the agenda because it exceeds, will be agenda because it exceeds the purchasing threshold limit that the code currently has for the manager, which is $25. So as a result of that, the council gets to weigh in as to contracts. So with that, this is the plan. The language of contracts will be the same language. For those of you who weren't council last year, will be the same language. Provided the anticipated hourly rates and the estimated days of work.
Are the days a week same as last year? The days per week the same as last year?
They're slightly adjusted. We had another contract employee last year in planning and zoning. That person left their company, and we found somebody for an internal regular town employee hire. We had a counselor who's made a point that they would like to see us move in that direction wherever we can. Opportunity for us to do that. So we brought in a full-time person, and we basically cut back on the number of hours of our 2 contract planners.
Who's the person that was brought in-house, was hired?
Paul Benz.
So therefore, Jason's days per week were reduced?
Well, Jason's hours and Kelly's hours are reduced slightly. He's replacing Sarah. Our goal is to have 2 people here every day.
Sorry, this new person replaced Sarah, did you say? See, I don't know this for kids, but did Robert, did his days increase from 3 to 4?
I don't believe so. I think that's a across the year average. So like at this time of the year, he's working more, and in the slower times of the year when the budget is not being prepared or the audit's not being done, or we don't have another sort of, major financial project going on, it's just day-to-day activities, he might work 3. So, really, this week he's probably working 5. Other weeks where he'll.
I was surprised to see that Chad was listed not as an employee contract, but a professional services agreement.
Yes, that was his preference. If that's not something that the council with, we can talk. When he came to us, he had basically his consulting firm of 1 for that, and he's running a firm rather than a person-to-person situation.
Okay, so he's with a firm of 1.
He's with a firm of 1 himself, and
That was what was puzzling me.
And I suspect that has to do
Know the
with
feeling.
his ability to cover some of his costs in terms.
I understand better now, thank you.
He doesn't have any other clients, as far as you know?
The questions?
Do you ever see a point, Roger, where we would need a finance director in-house, full-time, year-round? All the stuff that we're talking about doing going forward?
Well, I think, I think that we're not quite in through the sort of transitional period. We're close, but we're not quite totally through that yet. I think, can go look at the finance department and how that's staffed in the upcoming year and see if make some adjustments there. But I feel that at least for the short term, that continuing what we have is probably the best course. But if you're asking me if this is a longer term commitment than a year, the answer is no.
Okay. The final discussion item here is item G, which is the proposed budget for fiscal year 2021. Start that off, Roger, or?
Yes, so typically at this point, we've had preliminary discussions about the budget, and those typically evolve around personnel, equipment, other operating expenses, and capital. We provided you with a backup on the budget, and all of you, and I thank you very much for coming in advance of this meeting and going over your questions with me. Either some of you came in, some of you asked me questions on the phone, and I appreciate that. So I believe we're at the stage to really discuss, well, what things, differently will we be potentially doing next year. I'll stop and take a pause right there and see if you all feel that you're ready to move into that. And if you are, then we'll go through the list.
Sure.
Quick question. So this is going to be a loan or like a line of credit?
Okay, so your question, Councilor Veach, deals with the $10 million potentially for the 3 projects. So while the projects are basically being constructed, it's a line of credit because they don't give us $10 million on day one.
Right.
So there's a line of credit. We anticipated, as based on the best information I could glean from the readiness of the community, the readiness for the council, how many, where we are in the decision-making process, that it would probably take 3 years for the projects to be constructed. Completed for design and constructed. And once the buildings are constructed, basically, and the disbursements are complete, then we can basically convert that to a loan, and the debt service payments kick in at that particular point in time. Now, it's my intention to begin, rather than get 3-year vacation and then start making debt service payments. What I've told the bank is that it was my intention to begin making those payments on day one, so we don't sort of get into a balloon situation once we convert to the debt service payments. Does that answer your question, sir?
So we only start paying.
Now,
for it-
if we can cut the construction period down, design and construction period down to a shorter than 3 years, it'll be cheaper. So the quicker, I'm not advocating to rush through that process, but that's a fact. The quicker we get through it, the cheaper it will be.
Roger, if I could, I'm going to ask you a series of questions because I think there's some confusion amongst the public as to how these 3 projects are funded. You and I have talked a little bit about this, and I'll just ask you some quick questions to help clarify this, because I do think there was a sense that last year's mill rate increase was somehow, and I think it was, purposely designed to help fund these 3 projects, but it wasn't, it was to help service the loan projects, not to fund them, and I think there's some confusion about that. Also, it wasn't enough to service the loan, and so I'm just going to have you walk you through briefly this, because I think it'll be helpful to the public. It's a $10 million loan, correct? I'm sorry, line of credit
That's
slash
what's
loan.
contemplated.
Okay. Seaside Park, 1.2 million. I know it's flexible, but that's the goal, correct?
That's the current goal. It was actually a little bit less than that initially, but
That's fine. Times Square, 3.2 million,
yes, approximately, right?
approximately. Bay Oaks, approximately, or roughly 5.5 million, the remainder of the loan.
Yes.
Okay. So the mill rate increase last year, again, let's talk about the servicing of the loan. I think you and I discussed it's about $550,000 annually. Is that fair?
558.
558, okay. And then the mill rate increase from last year generates about $275,000 a year, correct?
Yes, sir.
Almost about half of what we'll need to service the $10 million loan, fair?
That's correct.
And then, because we shifted, I think appropriately, we decided to stop subsidizing the stormwater system with general fund dollars and adjust the rates appropriately to reflect the cause of those rates, which is the various users. That freed up some money in the general fund that can go to also help service that loan without increasing the mill rate. Is that correct?
That is correct.
That number is, I have 2 numbers on my sheet, that's why I'm asking. Was it $251,000 a year, or was it $320,000? I can't remember which one we discussed, or ballpark.
It's based on the mill rate, so it varies with the millage, but basically, it's the balance of what's necessary to make that 558 payment.
Is it closer to the 251 number or the 320 number?
Closer to 300.
Okay. So by no longer subsidizing the stormwater system with the general fund dollars and the mill rate increase of last year, we now have the ability to service the principal and interest on that loan of $558,000 without raising the mill rate additionally in this upcoming budget. Is that fair?
Correct.
And the loan will be for how long? How many years?
The 3 years for, it's 3 years for the build out, and I want to say that I sent you the debt service sheet. Unfortunately, I didn't print it out for myself.
20.
I believe it's 20.
Okay. Those are all my questions. Thank you. That's very helpful.
Else on that particular matter, the loan process? Not, we'll go on to the add-on list or budget.
Okay, so what we try to do, we gave you a preliminary copy of this when we gave you your budget books. in June, late June. What we try to do is, just to make it easier for you, just to highlight any clarifications or changes that have occurred in the interim. So I think the first point, and perhaps the most important point of this entire discussion, is for the council and the public to understand that the town has almost $4 million in the bank. And if you see on the top right of the page, you'll see a number right above that little gray highlight. That's $3,874,315. And those amounts are the reserves that we have. And these are things where we have made a decision to set aside money for specific things. So we have a reserve for beach renourishment, compensated absences, legal, operating, and emergency. And you can see that even with funding all of those reserves, we have an unassigned fund balance of $1,618,000. Our recommendation, as it's been in the past years, to use $729,000, almost $730,000 to fund our annual capital improvements, recurring renewal and replacement program. And that's something we've put in place just so that I'm not coming here and say, well, I have bad news, the elevator's broken and needs to be replaced, or something else, and we have no way of funding it. And when municipalities do that, you create either peaks and valleys in your millage rate, you get this fluctuating millage rate, or you are constantly putting yourself in the corner because you have to rob Peter to pay Paul. So I believe that it's very, we know what our assets are, we know what the service life is, and it's only appropriate, just like any condominium would, to begin to set aside money for things that we know are coming. I wouldn't want to live in a condominium where I got a notice in the mail and say, well, bad news, we have to repair the roof or replace the roof, and by the way, here's a notice for a special assessment of X number of dollars because we haven't begun to collect any money for this in advance, well knowing that the roof had a certain service life.
Does this include money for that are target of the redevelopment like Bay Oaks?
No. There was some money in there for minor renovations to Bay Oaks, but not the extent of the project that has evolved over time. I spoke to the Bay Oaks committee earlier this week, and clearly they're all excited about the different plans for the property. And I reminded them that the project, and when Councilor Adderholt was going through those numbers, I wanted to remind them that the project really started with the entrance lot in Bay Oaks. That evolved into, well, shouldn't put a building on there, and then if we are putting a building there, what are we doing with with their other building, and looking at the rest of the property. And I think taking a holistic approach was the correct thing to do, by all means. But clearly, the scope that was envisioned 12, 18 months ago has changed dramatically, particularly in the Bay Oaks. So I guess just to close the reserves, we have made a conscious effort to fund the reserves at an appropriate level for a town and population of this size, and that's been accomplished. And we've made a conscious effort to make sure that our assets can be replaced when they receive the end of their service life without creating financial stress on the millage. So that takes us to the upcoming fiscal year. We anticipate we will have additional revenues above our projected expenditures of $315,000. We believe that we will have actually have in hand or roll forward into next fiscal year, grant reimbursement of $100,000. As well as, so that begins to create a pool of money that's available for potential expenditures, for initiatives and other things that are needed in the upcoming fiscal year. And as a note, we wanted you to know that that number has grown from the last report we gave you. It is now up to $1,161,35.
Just to underline that point for 1 second here. You hear a lot of banter around at times, people saying, oh, you're going to be in such higher conditions because of the COVID, because your revenues are down, your parking fees are down, your other fees are not going to be collected, and this and that, and you hear all this, the naysayers say all of this stuff. The actual matter is that really not going. I mean, we are taking a minor hit in some of those areas, but as compared to a percentage of our revenues where those revenues are derived, i.e., ad valorem, it's really a very small percentage of what we're talking about here in this budget.
Yes, sir. I think one of the things that we try to be very, very careful about is to maintain a structurally balanced budget. And part of doing that is, or subscribing to that concept, is not to create a scenario where you're overly optimistic on your revenues, because if you have a blip for any unforeseen reason, you're immediately out of balance. So the next thing that happens is you're laying off people, or you're shutting down services, or you have to, increase millage next year to make up for your shortfall in the prior year. So we're extremely careful about what we set for our revenue projections, and we only account for what we sort of know that we're going to get, not hope we're going to get. Hope what we're going to get, well, that falls into this category of money that becomes available next year for allocation by the council. It doesn't come to pay our bills from last month. And we're extremely careful about that, because I've seen councils and commissions do it the other way, and it's great when things are going good, but as soon as you have your first blip, extremely, extremely painful.
Another point that certainly in the analysis that we were doing about the fire department and the sheriffs and the calls we get, is that, our island, being a little tourist town with relatively few residents, we generate a lot of bed tax, a lot of sales tax, and that money goes off to other entities and some comes back. That's very variable income. We took a big hit with COVID. But since we don't get that, it's a big part of the budget that we're not dependent on it. The parking was a hit as far as the income. Now seems to be, in my view, the parking seems to be because there's a lot of people on the beach. So by not getting that money, we're not used to it. We help with some of this COVID.
All right, I think a lot of people think that the tourist development dollars and some of the other state revenue dollars come back to the town in a significant way. Well, they don't. They come, the state revenue dollars, the state has what I would call a minor revenue sharing program that we get some money from, but in our overall scheme of our total revenues, it's minor. And by the way, they've noticed us, it's going to be half or less due to COVID. Again, because we don't budget that to the max, but it really as a minor revenue, we don't put ourselves in a position where now we have to make up for it. with respect to TDC, the money we get back is basically what we get back from the TDC grant. So we're in the pool with everybody else. We applied to them for grants. They've generally been supportive of the town's ask, but this year, they themselves face some revenue constraints. And as a result of that, sort of new capital projects have unfortunately, at least at this point in time, appear to will have to be put on hold. And I believe the vice mayor updated you all about that at the last council meeting. But it's important to understand that, I think I could say this, that, you know, we really wish that our ability to utilize TDC revenues would be a little bit broader than it currently is. It's very restrictive on what's eligible to be utilized. And it's heavily scrutinized by the county through multiple layers of review, where they say, yes, this grant or this project is directly tied to tourism. So while we are a cash generator in that regard, we disproportionately receive the benefits of that generation. And I think, I know most of you know that, but maybe not everyone else out there knows that.
All right, thank you very much, and I just want to compliment you, Roger, and the staff, and Robert, who I know is here, for this document. It's very user-friendly. I'm an accountant by trade, so I don't have any, but the flow of it is very easy to read, and anybody that wants to take a look at it, I'm sure the average person could make their way through this very easily. So, thank you very much for that. And if there's no other questions, we'll...
Mr. Mayor, I have just
Sir.
a real quick question,
Okay.
going back to the loan for the capital improvement projects. Obviously, you know, sitting through the Bay Oaks meetings, everybody wants everything. And depending on what it comes back, I think none of us are naive to think that it's going to come back within the budget to get everything that we want. Is there a plan, if there is a will to move forward, to do everything that everybody wants, to be able to pay for it? I don't know if I worded that quite right, but if, for instance, it comes back that it's $8 million to do everything that everybody in the community wants to do, and the will of the council is that you want to move forward with it, is there a plan in place to how we're going to finance that?
Well, no, I think there's sort of two approaches that I've seen in the past throughout my career. And one is that we're going to augment the town's money with naming rights and this, that, and the other thing, and we're going to sort of build a project on the front end with those assumptions. We're going to get this grants, and we're going to get this, and, you know, someone's going to adopt us and give us the money, and all those types of things. So the approach that we're really taking is, let's see what we can do with this money. Let's get actual bids in. Let's value engineer bids in terms of, is this a good price? Is this a good time? Is there a synergy between doing A and B now versus perhaps putting B off? Let's look at all of that. Now that we have a viable project that's really going forward and there's stuff coming out of the ground, now you can get grants. Now you can perhaps, you know, get some donations and contributions from other sources. And then, yeah, we may still have a gap or a delta at the end of all of that. Well, we'll sit down, you know, with this group as well as with BORCAP and figure out what it will take to complete something that we think is a high priority item if for some reason it doesn't make the initial cut. But, you know, I don't know very many communities that basically are in the stage that we're in and we're saying, yeah, let's just fund the whole thing. Everybody goes through this process of value engineering and assessing how badly X has to happen versus Y. And we'll do that. You know, I think one of the simple cases I could make is that we need to knock down the existing building on day one or not. Or, while I think we all agree that building needs to be replaced, I don't think it needs to be replaced on day one. So how do we work the phasing of the project to allow that building to stay and continue to be in use while we're building out other elements? When we get to the point where that building can't be occupied, or we have the financial wherewithal to move forward its replacement, that's what we'll do. It's not going to be a brand-new house. I want to be clear. It's not like, you go close in your house and you walk in and it's a brand-new house, brand-new model, brand-new everything.
Oh, come on.
No one ever else has been in there, on day one. It's going to be a phased approach. That's the only way we could do it, that I can see. And I know some people might be a little bit impatient about that. Don't forget, 18 months ago, we weren't even talking about this at all. We were talking about a little, whatever it was, 100 by 70 lot, doing something there. We have really gone far down the road in recognition of what God would like to see for the town. And now, just need everyone to be a little patient. We will get there. My intention to get there. It's my intention to get there, within the next 3 years. But it's not going to be overnight.
I think we're all looking to a post-COVID big party out there, or a concert out on those fields, and have the whole community come and have a good time. That's and the rest of it is politics, my man. That's the way that works. So anyhow.
Mr. One other
Yes, sir.
small, and again, I apologize to Councilor Allers. I got home from the council meeting on Monday, and my wife chastised me for not being more responsive to a comment he made, but I actually was reading my notes and I missed what he said. Councilor Allers, would you repeat your concern that was expressed to you about the fees going up in Times Square? And again, I apologize for not being, I went back and listened to it, and I realized what you said. I'm sympathetic to it, and I wonder if there's a minimum we could offer a small gesture, considering the tough times that we're in, to address the concern that you raised on Monday. So if you would restate that, that would be really helpful. I think it'd be appropriate with this budget time.
Yeah, there was some concern with, in October 1st, the square footage fees are going up $2.50 for the Times Square merchants.
What are they now, Dan?
I don't know the exact dollar amount. I think it's going to go up to, $12. I think it's at $9 now,
It goes up
$9.50.
$1 a year, if I remember correctly. Do you remember?
October 1st, I think it goes up $2.50, and it puts it about like $12.50 or somewhere in there per square foot. I don't know the exact dollar amount. I had it written down, but I don't have it with me. And being restricted the way that they are with COVID and only being able to use 50%, and they're paying for space now that they can't use. And, I just think it'd be a good gesture if the will of the council would be to not necessarily get rid of it, but maybe an extension on it, review it in 90 days, or whatever we can do to maybe show good faith that, we're all going through this together. And even though it may be just a small gesture and it's not a ton of money, but to them it could be a ton of money. So that was the reason I brought it up. I had several businesses that expressed some concern to me about it. And I brought it forth, and at the time there was really nobody that said anything, so it kind of stayed there. But I thank you for bringing it back up.
What kind of budget like this would have?
Well, to be perfectly honest, I'd rather know about it today versus, in September or some later date. So, if the council were inclined to move in that direction, for a short period of time to see what happens with COVID and things, because it is a very dynamic situation. We're all going home and watching on the news how things are literally changing day by day. I'm sure for sort of the first quarter of the fiscal year type thing, it wouldn't be insurmountable for us to absorb that if we had to. Again, by then we might be having other revenues and other things that are doing well that I could advise you that would have no impact extending it for another quarter, but I just don't know that today.
Just to be fair to the taxpayers of Fort Myers Beach, I have to take the other side here. I'm not going to debate this with you right now. Everyone's always looking for a deal, and I appreciate that. I'm a property manager myself. But, while these discussions are being held, you can also look back to the history of the payments that have been made down there, and as to how many years town waived any fees down there for that space to the businesses, and also how many years subsequent to that the businesses paid a below-market rate on the price per square foot of the space down there. So I'm just putting that out there so that the other side can be heard, so the taxpayers are aware of the situation.
Mr.
Anything else?
Mayor?
Yes, sir.
Just on that subject, the other thing is that, I guess I'll just take this opportunity and we give these folks the ability to use their properties as an extension of their restaurant premises. Not necessarily for other uses, it's based, best as I know. The current rate is $10, and it will be going to $12.50 if the council doesn't hold back that increase for 90 days, just so the numbers are on the record.
When is the increase due to?
Go first.
Could we consider doing it till the end of the year? That way season would at least be starting?
That's why I said the first quarter basically would be January 1st. And we can revisit it in December and see what's going on and what the appropriate thing to do is at that point in time. Be closer to season and have a lot more information.
Okay, thank you. Okay, the final item on the agenda is
A couple more things on the budget that we, down near the end.
I'm sorry.
That I'm a little curious about too. Now, I see that you have the Hercules, Coconut, and Del Mar
Yes?
docks. You had talked before about trying to, the idea of floating a neighborhood association that is responsible for maintaining and fixing those eventually?
What we decided was we would only fund half of its replacement. So those numbers have come down, an annual amount based on, I believe, a 15-year service life. We're accumulating our half of that money, and we're in the process of notifying the neighbors that should they not take any action, a proactive action, that will be an issue in 15 years. They're willing, I'll be here to be sitting in the audience somewhere to tell you about it.
Another thing is the snowbird lobbying initiative. I wouldn't mind knowing more about
I
that.
believe that's Council Adderholt has talked to the council about that, but I'll let him fill in the details.
I appreciate the indulgence of my colleagues on this. This is something I talked about during the campaign, and I think we talked a little bit about it on Monday in the sense that the governor 2 years ago announced this initiative, a $2.5 billion initiative for quality water, not only reservoir capacity, but Everglades restoration. And that's been extremely successful. Both years have been fully funded. Of course, one was discussed prior to a presidential election, and now we have an election before us now, which is really helpful in stimulating the interest in our policymakers. And I think, particularly with the constriction of funds to the state because of COVID, again, commended the governor for when he made $1 billion in cuts, he didn't cut those funds. But next year, there really is minimal election activity. If we continue to have, Lord willing, clean water, it's going to be more and more difficult to keep our policymakers focused on this initiative because the dollars are substantive in terms of really making an impact. And these dollars have leveraged significant federal funds over the last 2 years. I mean, record number of federal dollars. And again, they will also not be in an election cycle next year. So the goal is to put forth an initiative. Initially, I thought it would just be primarily earned media, but I don't think that's going to cut it. We've lost one of our newspapers. I think what I envision with the modest budget, and it would be to put together 3 different mail pieces from the town, all the addresses, and then explaining to them exactly how to contact their federal legislator. These would be folks, again, from Ohio, Michigan, wherever they come from, Indiana, Wisconsin, and they would then write their members of Congress. We'd help them understand how to do it, the importance of doing it, and they would go and write their members who represent them in Ohio. And all of a sudden, you've got somebody who's in the district of somebody who chairs the Appropriations Committee in Ohio, and all of a sudden they're getting a letter about the importance of Everglades restoration funding, and maybe they get 5 or 6 letters. I'm just telling you, based upon my experience, that has an impact, because if we write them from Florida, they're not going to care as much, because they're obviously more interested in their own constituency. So that being said, I would like to help mobilize an effort. And again, when you look at lobbying costs, $15,000 is very modest. And this would be, we'd work with our new town PIO to help facilitate all this. And then we would also encourage those who are in Florida here to contact their various state legislators throughout the state to continue to support this $2.5 billion initiative. And I think particularly, again, we've been so blessed with clean water since 2018. We're losing the interest of some. And we're also, not being a non-election year, this would be our contribution. Hopefully, if we do this right, then other communities around us would model it, and we could really get a nice effort to try to apply some real grassroots pressure on our representatives to help continue to fund this important project.
So your idea, this money would primarily be used for things like mailings.
It'd be 3 direct mail pieces. I would envision some potentially paid media in maybe certainly the Observer and possibly the News Press. I don't know if that's quite as cost effective. And just we may not need to use the whole 15,000. I think we could do probably the 3 mail pieces for around 10 to 11. I'd like to run some decent half-page ads in the Observer, again from the town, explaining how to reach the importance of what we're doing, how to do it, and kind of give them some guidance on what to say without scripting it. And then we'll do this in a way that obviously will keep everybody informed, keep everybody in abreast of what we're doing and how we're doing it, make sure everybody's comfortable with the language, the content. Yes, that's how I see those costs being spent.
One thing I think you might consider, if it doesn't already exist, is some kind of Facebook group, whether social media for snowbirds.
I think that's a great idea. That's not my forte, but hopefully our PIO could help with that, but I think that's a great idea.
I would support your initiative. That sounds
Me too.
very good.
Thank you, I appreciate that.
That's all I have.
Okay. Let's see if we can bang out this agenda management. Anybody want to start this?
Well, one question I have is about things that we were discussing that were not necessarily on this list. I don't know when the appropriate time to bring that up is, but I would like us to arrange or have a discussion on public safety.
We're on the list, right?
Public safety from traffic perspective, from
Criminal activity.
criminal activity. Okay.
We started this discussion. I don't want to necessarily just die right now. I think there's a lot of things that we could do as a community, even more than our
Yeah, I've reached out to the public, some members of the public,
Safety Task Force.
yeah, and asked them to come up with some ideas for things along that line as far as what the community can do with public safety, community watch groups, things like that. So hopefully they'll be able to come up with some ideas for us.
I would agree to put it on a future M&P.
Also, you could get the word out. There's a lot of retired cops on the island here, that probably have some experience to share, and attorneys and so forth, and just make a real mess of this whole thing. But
heard that the neighborhood watch has really worked well in some of these areas. And
yes.
the other thing I think is use of cameras, both personal around people's houses, maybe, some law enforcement, retired law enforcement with how to place the cameras so they do some of those shadows that now with is going to help us get rid of some.
I think it'd be helpful for people to understand where the current neighborhood watch groups exist and how they started and how they were successful, and because I don't think a lot of people know who has them, who doesn't, and how to start one, and that might be helpful just to have that conversation as well.
I have an addition
Go right
to
ahead.
the agenda management. For a very long time, Sarah and Patty and I were working on a redo of our special events. I recently submitted to Roger and to John for legal review and administrative review our final draft, and I'd like to see it put on agenda management so that we don't let it drop through the cracks. So you guys have some date that you think it would be ready, that we could put a date on here and,
Yeah, that was my question. Does the council want to see it at the next MNP or on a regular agenda?
You, Vice Mayor,
I've worked it through, so I don't need to talk about it anymore.
put it on the agenda.
I think it's ready to go straight to the agenda.
First meeting in September?
It looks like there's room on here because I don't see anything else in September on the regular council, except for LDC text amendment. It should be room for it on the agenda.
Yes, I saw what you transmitted, Vice Mayor, and I had some further thoughts that perhaps we could even maybe simplify it a little bit more, that I'd like to at least just have a quick conversation with you at your.
Sure.
But I don't think that would interfere with the date that you're talking about.
Okay.
Anything else to look at or add or subtract?
One more thing, I'm not really
Multiply?
sure where this conversation belongs, but, we're in the middle, we're getting into the peak of hurricane season during a pandemic. We certainly face some challenges, the guidance has changed where they're going to essentially tell people to stay put more than they would normally in a season, but we're on a barrier island it has to evacuate. I have had some conversations with Jill Palmer from the Red Cross about their plans when they do have to go into shelters. There's also a good website that has a list of hotels. They call them non-congregate shelters. People can go here, they're infectious or vulnerable, and they give a list of where they are, how they're rated, have generators or not, this kind of thing. And if you get that information out to people, it becomes
That comment during my comments at the,
On the Red Cross site?
the one is the Red Cross site. The other one is, I don't know, my wife actually brought it to me, but I can send a link if possible, maybe through.
Maybe we could even give it to the PIO for her to put out.
That'd be good.
We can promote that.
The procedural question, because I'm still trying to understand how the agenda management concept works. Would the nuisance abatement ordinance go on the agenda management calendar, or does it just go to the next council meeting? How does that work procedurally?
Yeah, you'll see it on the next calendar, which will come out after you already had the first reading, just the way the timing works out.
It's okay, I'm just trying to understand the process. yeah.
So, just to help you, and perhaps some of the people who've been counselors for a long period of time will help me, this is really just to keep track of the sort of the council's to-do list, if you will. Generally, an item will appear on the agenda management. Two or more counselors express a desire to delve into a particular topic. In some cases, it's set for a date certain. In some cases, it's not. Because this is typically discussed once a month at the beginning of the month, it basically picks up the things from the previous council meetings, gets updated, you see it again, and then you'll see it again at the beginning of September. Typically how it goes. So what you add on it now will show up, and it'll be in September. And it's just a tool for all of us to not lose track of matters that the council would like to discuss or deal with.
Thank you. Just one other additional procedural question. Do we have the dates and times of the September meetings yet? Are we still waiting to?
We do have the dates. The budget portion of the meeting is at 5:01 PM. Only two
Give me a-
times that we have required to have night meetings.
Are they the same dates as our normal council meetings then, or?
I believe we have dates that we've cleared with Lee County and the school board.
No, sir. For the budget hearings, we have to coordinate with the county school board, the county board of county commissioners, et cetera. So we've established the budget hearings will be on September 10th, which is a Thursday, and September 21st at 5:01 PM. And we've tentatively set the September management and planning session for September the 3rd.
9 o'clock.
At 9 a.m., yes, sir.
That's great, thank you.
Mayor, is there a spot in here that we could allocate for potentially having the Lee County Sheriff's Office come in and provide us with some information about different types of things that we can do as far as increasing the police presence on the beach? There's several different options. There's 7 different models out there that are available. It wouldn't take a tremendous amount of time just to allow them to come in, put some numbers we could potentially talk about down the road.
You know, if the sheriff wanted to come down here, we'll always make time for him. Wants to come down and chat a little bit at the beginning, we can send him on his way anytime he wants.
I told them I would follow up with them after this meeting to see if it was all right to have them come down at our next scheduled meeting to just give us a brief presentation before we start. If everybody's
with
okay
that.
with that?
Yeah. Okay, anything else for the good of the order? Yes, sir.
Items, very quickly, Mayor. I've emailed to all of you a notice of dismissal with prejudice. It's already been filed with the court in the patent matter.
So you negotiated while you were sitting here?
Multitasking. So that's been filed and that's officially over. Also, in anticipation of the next regular council meeting, I will be reaching out to you all and following up with you all on the Dune walkover settlement proposal. And I will need direction at the next meeting with regard to how to proceed in response to the settlement proposal. Otherwise, then we just follow the normal statutory procedure, which is our response is due in 150 days.
When will you be reaching out?
Over the next couple of days over a few minutes.
Might I suggest that we all communicate privately with John because of the fact that we can't hold an executive session? I'd rather not reveal our hand.
And that's my intent. To reach out to each one of you all and just confirm our conversations at the next meeting so I can file an official response to the settlement proposal that property owners have submitted. That's it.
Or did you think it was a good idea to invite guests to describe some of the public safety measures that they're taking to address some of the issues we've been talking about, or do you think you can handle that?
Other people from other,
Yeah, just
He's talking about the email we got.
email we got on Monday about some of the steps that were being taken.
oh, yeah.
I think that would be helpful to have an in-person opportunity, I guess, to discuss some of those.
No, probably yes, but probably just wait a little bit and let things settle and
However you
if
want
that's
to handle
okay.
it. That's fine, however you want to handle
If you-
it.
if
I
you-
just want, I want them to know that
That's
they're
my
welcome.
judgment.
Yeah, yeah.
it's a good idea. Just to keep things moving. Okay, if there's nothing else, it's 12:12 or so, 12:13. We'll adjourn. Thank you. Oh, well, there's lunch upstairs, I think,
Yes.
right?
Yes, we anticipated it being a long meeting. You moved it along very quickly, but we still have lunch upstairs if you're interested.